All right. Well, good morning, everybody. Thanks for joining us today for this live hearing of Karen Reed. Got another very important hearing today. And always, as we've come to expect, there's probably going to be some fireworks because that's usually how these things go down. Even though everyone's keep trying to tell everybody to calm down. And Judge Cannoni at last hearing said, okay, let's stop with the insults. But hard to stop. So we'll see if that continues today. It's going to be hard to stop that. But I did see, before the hearing gets started, I did see just recently that the defense filed a response to the third-party culprit defense motion. And this was the motion that Hank Brennan wanted to argue at the last hearing that they should not be allowed to introduce third-party culprit evidence. So I did see a response to that just come in this morning. Somebody was nice enough to send me the PDF. Appreciate that. And some of the arguments actually that we made on our channel appear in this brief. Not surprising, but it's good to see. So the first argument really that they make is that you do not have to identify one individual as the third-party culprit. You can have an array of people that you think are involved, and you can bring in evidence that any one of these possibilities could be true. So as long as you have some evidence, as long as you have some to be able to prove motive, opportunity, intent, then you should be able to show that evidence as part of court. I also do want to let everybody know that StreamYard keeps updating its software. So hopefully we'll not have any glitches today. And you'll let me know as soon as I try to share my screen with the I'm going to try Court TV, their stream. Their stream has been pretty good. So we're going to give all credit to them for this live stream. But we're going to try to share it. If you have any issues, let me know right away in the chat, and I'll do what I can on my side to make sure you can see it and you can hear it well. So let's just start with this question, because I am keeping an eye on it. So as soon as it gets started, I'm going to cut to it. So here's a question by Ashley Rose. Didn't they try to submit third-party culprit theory during the first trial? And yeah, they did. They did actually try to do that. So I know there's some limitations that Judge Cannoni tried to impose and say, you can't open on it, even though in that he kind of did. But there is definitely evidence that they introduced of third-party culprit. So in this response, they go through the three people, Brian Albert, Brian Higgins, and Colin Albert, why they had motive, opportunity, and intent to commit this murder, and that they intend on introducing evidence to that effect. So we definitely going to have that. This is what their argument is, at least. Also, just another point that I made in my previous video when I was analyzing this third-party culprit argument by Hank Brennan and his motion, they said in there the following. This is what Hank Brennan said: that the defense must prove that another individual had the motive, intent, and opportunity to commit not only murder, but vehicular manslaughter and leaving the scene. And that obviously is not correct. It's an incorrect statement of the law. And that is something that they pointed out in their responsive papers, which is great. Is that what you're supposed to do? But then they cite a lot of law here, so we don't have time really to do a deep dive into the response. But they do go through each one of the parties. So until the stream starts, I'll just tell you what they say here as it relates to each individual person. Let me just pull it up there. Oh, hold on. I have to go back up. Hold on a second. Here we go. Here we go. Brian Albert. Brian Albert did not have a good reputation among his fellow police officers. He was known as a bully, someone who has a history of sucker punching fellow officers, particularly when he was drinking. He has been investigated by Boston Police Department's Internal Affairs Division for his violent conduct in that regard. Albert is a trained boxer, and several of his fellow officers were afraid of him. Brian Albert was present at the scene of John O'Keefe's death on January 29, 2022. John O'Keefe's lifeless body was found on Brian Albert's front lawn, just feet from his front door, and the door to his garage. Brian Albert admits to having been home at all relevant times. The evidence, including computer forensic data, overwhelmingly establishes that John O'Keefe entered Brian Albert's house. Brian Albert was drinking heavily throughout the day and night in question. Brian Albert spent the day and night with Brian Higgins. In the weeks leading up to John O'Keefe's death, Brian Higgins had demonstrated a romantic interest in Ms. Reed, Mr. O'Keefe's girlfriend, but he had been rebuffed, essentially ghosted. And on this night, Higgins was confronted with Mr. O'Keefe and Ms. Reed together and clearly happy. Higgins' words and deeds revealed significant aggravation. Brian Higgins was in Brian Albert's home when John O'Keefe entered. After a period of time, Brian Higgins left the Albert residence, but maintained contact with Brian Albert. There were suspicious and unexplained phone calls between the two of them at 2:22 a.m. on January 29, 2022, not long after Mr. O'Keefe was mortally attacked. This is the butt dials. Mr. O'Keefe had injuries and wounds on his right arm from an animal or dog attack. Brian Albert had a large German Shepherd at the location on the night of the attack, a German Shepherd which undisputably had a history of violent dog and human attacks in the past. This aggressive and violent German Shepherd was, according to Brian Albert, not good with strangers. None of this evidence was investigated by the police in charge of this case. In fact, the evidence shows that was by design. Ex-Trooper Michael Proctor was asked in a text exchange. Oh, you know what? Looks like they're cutting right away, so let's pull it up. And you let me know if you can hear everything okay, all right? I can't hear either right now, by the way, so that might be Court TV's issue. And in the meantime, I'll look for another stream in case they are playing the audio in some other place. Give me a second here.
Third-party culprit, or whether it applies to a third-party culprit aspect of Bowden, those concepts are logically and legally distinct. It is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses.
Can everybody hear what's going on in court? Because this is from Law and Crime Network now. Does everybody hear it? Please let me know in the comments.
But the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose. They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant and national broadcasts, there's no evidence of that. There is no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation.
So Hank Brennan first starting with the third-party culprit, and was exactly what we were talking about right before the stream started. This third-party culprit defense, he's arguing that they should not be allowed to present it. There's not enough evidence. And he's starting off with Colin Albert. Between Brian Albert and Brian Higgins and Colin Albert, his strongest case is for Colin Albert. And that's probably why he's starting with him. Once you get on to Brian Higgins and Brian Albert, that's not as strong anymore. So he is starting with his strongest argument, which is sometimes what attorneys do.
The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relayed that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, and I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it, and even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department, but that is not the issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door, arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the way data in the GPS and all the data puts John O'Keefe at the front yard, not in the house.
Well, not the data that on his phone that says that he went up and down 3 flights of stairs. That one, I think he's choosing not to discuss. We'll probably hear that from the defense, though.
So if they're asking a substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night. Finally, the defense turns to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Ms. Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Ms. Reed went to Mr. Higgins' house. And so there was some interest, it would appear, from the text messages between the two. Mutual, at best. There's a plethora of text messages where Ms. Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. In one, she says, of basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night,
whoever heard of somebody who's interested in a girl and that girl is with another man, that he would have any animus towards that other man? Who's ever heard of such an idea before?
Sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins' text messages are virtually all kind towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house. Is it reasonable? Is it rational? Is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways? The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It will be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue to the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. That's their support. What they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So they are parsing words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon. What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit, who actually have relationships to the scene or the crime or the deceased. In this case, an attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this, that there's actual evidence that there's this alternative theory, and they failed to do it. To have the defense go through a trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction at the end. It evidenced the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden. Even if the defense at the end does not warrant an instruction, I recognize that challenging a police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their investigation as being criticized, they would have had to have known about a potential third-party culprit or third-party culprit evidence and didn't pursue it. And that's where the defense argument utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead. And a number of witnesses knew that Miss Reed was saying, I hit him, I hit him, I hit him. A number of witnesses. Shortly thereafter, what the police knew is that Miss Reed's taillight was cracked. And shortly after, what they learned and knew after they got her car is that part of her taillight was missing. So at that time when they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview and they spoke to the owner, according to the witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover-up, no turned over furniture. There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed.
Because they searched the house, of course, and they were able to see that there's nothing turned over. Oh, wait, no, they didn't search the house. All right.
Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order to have third-party culprit under Bowden, the police would have to have known that there was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case. That is not this case. There is nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead. And likely the reason is because there wasn't. The evidence for a reasonable police officer pointed towards the statements, towards the car, towards the light, and that was followed up, which led to DNA in hair and all the other evidence that followed, the data. And so as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's not part of their entitlement. And mindful that if they do raise Bowden, whether they get an instruction or not, it is broad. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind why they did not do something. That can open doors to inadmissible evidence, privileged materials. The state of mind of the officer is relevant if they make it relevant. So we should not engage in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow a third-party culprit in the instant, and you should not allow it as part of Bowden.
So not only is he arguing that this evidence should not come in as part of the third-party culprit, but he's also arguing that to show that the inadequacy of the investigation, which is much more broad, which you are allowed to attack, and in fact he even acknowledged, is essentially an entitlement by the defense to attack the investigation. He's arguing that none of this should come in even for the Bowden defense. And again, a lot of this is probably what we're going to be hearing about in a second, but a lot of this comes down to this is argument. The evidence is what it is. Now you're arguing to Judge Cannoni that, you know, these are your inferences and these are your positions about the evidence. The evidence is the evidence. You can argue it your way to the jury. We can argue it our way to the jury. So a lot of it is really just, again, argument, which really should be going to the jury as opposed to attacking the actual evidence.
All right. Thank you. Yes.
Your Honor, the Commonwealth's motion raises three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of this argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the.
Oh, there you go. Law and Crime is deciding to do a little pause there. Let's see if we can get something else here. So first of all, it's interesting that those police officers are actually going to be on their witness list about Brian Albert's violent behavior. Let me see what else I can pull up here.
With that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard, where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being biased in this investigation. I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael
Come on now. Law and crime. Not sure what the issue is. Let's see if Court TV has it up now.
It's worth stressing that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, and the family 7 years, Brooklyn got rid of it. It was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case.
It looks like Court TV also is having technical issues. What's going on in there, Massachusetts? Come on. And by the way, I've got Court TV up also, but they are not. They're also having technical issues. See if we can get a different one.
Ms. Reed was the one to end the contact. She stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Albert's house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness. The jury in this trial should be entitled to consider who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. He claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in his.
He keeps saying ex-Trooper Proctor, former Trooper Proctor, like keep stressing that.
Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He had thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there are videos of him clearly desperate to beat up others. The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo. We don't buy it. We don't think a jury will buy it. When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was. But we found out when we sent a letter to Mr. Lally, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter notifying the prosecution that we were on to Colin Albert that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address. There appeared to be a conscious effort of these investigators to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, and I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Counsel versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, a person was murdered inside a home, just like this case. Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence, that the three potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial after the first first conviction was reversed, allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error not to permit a full third-party culprit defense, including prior bad acts of the third-party culprit. And I will ask the court to consider Commonwealth versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried the retrial of that case, so I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed a crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. It's sort of like Conkey, where it's just assumed, yes, of course you can present a third-party culprit defense. But in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer was yes. And in Finney, of course you can present a third-party culprit defense. But can you also introduce hearsay to support that defense? It was a given. In fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's agreed that we would deign to present this defense. And I would note, Judge, there's, I believe, a certain amount of gaslighting going on here in that on one side of his mouth, he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard. But regardless, in terms of these cases, Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim and or relationships to the scene of the crime. Finney did not. In Finney, my client was the next door neighbor. My client signed a confession to the murder. The third-party culprit lived several houses away within the same city, but not close, not next door. There was no relationship other than he made statements about how the victim probably deserved what she got, and she wasn't the goody two-shoes, but there was no, that she was made up to be, but there was no witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime. The SJC ruled even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue I suggest that the court does not need to decide now in advance of trial. Closing arguments come at the very end of trial. At the charge conference, this court would be in a position and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial and as a result of our proffer and our submissions and oral argument today to rule that a third-party culprit defense is permissible, but this court at a minimum should not deny argument on that issue before evaluating the evidence as it comes in. And that brings us to the final third issue, the Bowden defense. Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law. It's a bedrock constitutional right. In this regard, in one sense, the discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and or Colin Albert, all of it comes in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right. They were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement. And in their internal affairs findings, his superiors noted that his apparent bias was one of the reasons he was fired. You can't have a stronger Bowden defense than that. So I would argue, Judge, that the Commonwealth's motion really comes down to what the defense will be able to argue in this case. Our position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we would be allowed to argue from now, weeks from now, when closing arguments are upon us. This evidence, in conclusion, in our view, must come in. This is a due process constitutional right of my client, and it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this. And number two, it's a time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit evidence situation here than existed in either Conkey or Finney. And we assert it would be reversible error for this court to exclude this evidence. Unless the court has further questions, I would rest on my memorandum.
Okay.
Reed. I'm going to choose to focus on case law and the facts that aren't presented by the defense. We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical because there is no basis to accuse somebody of murdering another person if they don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple of derogatory words. In Finney, as counsel knows, there was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular. And because of this irregularity and the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so, no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision.
It's interesting that he's saying alleged collision these days. He used to be much more stronger about this collision.
Defense's effort to tell a story. Take a couple of facts. Someone's a boxer, they drank alcohol, and convert it into a story is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced because it is inevitably, it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation, and after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments. And so, although we don't know the parameters of the federal investigation and we can only guess as to some of it, we know from what we did receive and review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Alba came down the stairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, a first responder, was still outside that aid could have been rendered. That is just, it's not only speculative, it's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth v. Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later, the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth v. Moore. The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth v. Buckman, 461 Mass. 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole that looked like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward. Facts suggesting that one side believes a person's telling the truth or not facts of third-party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury. And I don't think the basis is anywhere close. It's feeble.
That briefly respond. Thank you. First of all, Your Honor, speaking about the federal investigation when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. It should not be a part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were. And with regard to the other case, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone, and we'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the plow driver, Mr. Laughlin, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. And unless the court has any questions, I would address them now.
Hi, thank you very much.
Thank you.
So let's go on to paper 620, the Commonwealth's motion for production of records regarding unsolved productions.
Yeah?
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We served the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through it. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they're forthcoming with a court order.
There's no one here from Unsolved Productions opposed to this.
There is not.
Defense want to be heard now?
Your Honor, we're unaware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first of the hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially has been filed one way or the other. So we're not in a position to argue on their behalf for sure.
All right. Thank you, Marcin. So, there's two things left to discuss. I want to talk about jury impanelment. We also have a Commonwealth motion regarding Mr. Yanetti's claim. Mr. Yanetti, it's 12:10. Which one do you want to go forward on first? Do you want to talk about the impanelment, or do you want this motion?
I'm not going to leave with those.
I understand, but do you have a preference what's done before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney. Still within the defendant's.
So here we go. This is the attorney-client privilege one that we were speaking about in the past few videos. See how this motion plays out.
You are so unclear. The Commonwealth is not seeking all communications between Ms. Reed and Mr. Yanetti. We're only requesting the communications that may be on any type of records in possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions. And we believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yanetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yanetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, 'Did I hit him?' I hit him." And the answer by Ms. Reed was, "I said, did I hit him? Question mark. And then, when I talked to David, now this is later, David said, 'Karen, if you incapacitated him in any way, there's culpability there.' And I thought, all right, maybe this is maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like?" Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, "And then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe in her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. If this was intentional, it wasn't secretive, it wasn't overheard, it was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any texts or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It's obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
I am, Your Honor.
And everybody gets excited. I am, Your Honor.
May it please the court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yannetti. 2 of the 3 instances of the communication they cite to are over 9 months old. And that's in 5 months old, respectively. So you have 9 months ago, the Gretchen Voss statements, and 5 months ago, the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion. Why? The courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the 3rd communication, the HBO Max one, It regards the same event that is discussed in the first two. There is no addition of an event in the third one. So that third discussion, the docuseries, regards the same events that have been extant in the first two that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion?
Canonical.
What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions, as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Golden case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point: in the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites the Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for my eyes, so the motion is denied.
Thank you, Your Honor.
Oh, the motion's denied. Okay.
need to talk about impanelment. The parties need 5 minutes.
All rise to the court, please.
Was that Yannetti saying good job? Or thank you for that? Oh boy. So, well, she just denied that motion. I thought maybe they'd also talk about the law that Alan Jackson was supposed to provide to see whether they can bring in an expert for police investigation. That wasn't brought up. So, wow, yeah, I don't think a lot of people were expecting her to deny that motion, but she did. So there you go. There you have it. They're talking about jury impanelment. Little break. Not sure if they're going to be coming back on the record or not, but we can leave it open. If there's any other questions, take some of those questions. Oh boy. I think everybody just loves hearing Alessi argue. Like, oh, come on, let him argue. Let him continue arguing. Let's just listen to it. I think somebody said that they like listening to Alessi because he teaches them new vocabulary every time he speaks, which always makes me laugh. But I do want to address this point. Leslie says Alessi showed up in Brother Counsel's chat on Sunday. Nice one. Yeah, so a person with the name Robert Alessi showed up in my chat on Sunday. But quite, I'm not sure if we would be right in assuming that was actually Robert Alessi and him going in under his own name, saying that, he's coming to watch Brother Counsel. Highly doubt that was actually him. But I don't think he'd go under his own name anyway if he's trying to follow us. But it was fun to comment about that. He's just great to watch. I think a lot of people want to see him do like an opening statement or closing argument or something like that. So, yeah, so that's with that. Okay, so just to understand what happened here, right? So we have Janice and Evan White. Did she just deny third-party culpability? No, that was not what she just did. She just denied the motion to get Yannetti's text messages to Karen Reed. Those communications she denied. So that's all she did right there from the bench, which she doesn't usually do. Usually she writes an opinion about it, or she takes it under advisement and issues an order later. So that's all that happened right there. So really, I mean, there's really only 3 motions that were argued today. Obviously, the main one is a third-party culprit one. I do believe that the third-party culprit should be allowed in. I think they should be able to present evidence on the third-party culprit. So we'll see what Judge Cannoni ultimately does. I think she may say, we'll see how the evidence comes in. She may say, like what she did last time, that she's going to not allow them to open on it, but they will be allowed to present evidence. And then maybe after the close of evidence, she can talk about whether they'll give a special jury instruction regarding third-party culprit and whether they're going to be allowed to argue in closing argument. So, by the way, let's pull this up. Hello, Sunshine. I can believe she's guilty. I'm not a juror, nor would I ever be one in this trial. I already have an opinion, and I don't live there. It's funny because there was somebody in my chat, I think it was on Sunday, who said that they actually were summoned to jury selection. So if they are summoned to jury selection, and they're going to have to fill out that questionnaire, and in the questionnaire it says that they're going to have to let the court know of what they've been following in terms of the Karen Reed case. So they may put down their brother counsel. So, but yeah, that's what you're going to have to do. Probably a lot of potential jurors have been watching this or following some sort of coverage on this case. So Here's a question, Glenda Carnes. If you can't confide with your attorney, how can you get a fair trial? And that's exactly part of the argument here. If the problem here is that if you disclose your communications with your attorney to a third party, well, that's where the argument comes in that you should be able to pierce the attorney-client privilege. So the fact that she was telling Gretchen Voss, and it was a Vanity Fair, and then this HBO Max docuseries. Well, if that's what she did, if she disclosed these communications between herself and David Yannetti, well, then that may be discoverable. So that was exactly the point of his argument. But again, even if technically you can have an argument for that, it's very dangerous, which is why I think Judge Cannoni wants to stay away from that. Start some sort of precedent or give some sort of a appealable issue to the other side about these attorney-client communications. So therefore, she's just staying away from it. She's saying you're not going to be able to get it. Now, what I thought is that maybe just strictly under the law, they may be able to get the communications specifically exactly what she said, but not the whole array of communications, not a broad set of communications that have anything to do with that specific statement. If she's just saying, David Yannetti told me this and that and the other thing. Now, again, like I said, there is some argument about at issue waiver, which is that if you put an issue in front of a third party, and therefore the entire issue perhaps could be disclosed and could be discoverable. So, but again, she's just not going down there, Judge Cannoni. She's just not going down there, and so that's why she denied it. I don't know if they're going to lunch now. It wasn't clear. It seems like she just said we have to talk about jury impanelment. So I'm not sure if there's going to be anything more on the record. I don't think there is. So this is what it looks like right now. If you want to see, this is what's going on now. They haven't stopped the live stream, but here's a question by Jessica Lee. Do you think they'll find her guilty this time? And the problem with that question is I haven't seen the evidence this time. I don't like to talk and speculate about what the evidence is going to be this time. And I really, really, like I've told you all before, I really want to see Dr. Welcher. His testimony, I think, to this time around is going to be crucial. If the Commonwealth wants to get a conviction, he is going to have to be extremely credible, Dr. Welcher. He's going to have to be an amazing witness. He's going to have to completely debunk the ARCA experts. And that's the chance that they'll get to be able to get a conviction on this case. But if they don't have that, then if it's all kind of the same that we saw last time, well, my opinion from the last trial. Last trial was pretty clear to me that they just simply haven't proven their case beyond a reasonable doubt. There's just way too much doubt there. So we have to see how this new case plays out. So I can't tell you that that I would what I'm going to see. I don't know what this trial is going to be. I think everyone's saying, anyone who's been covering this case and has been following for the past few months, attorneys, law tubers, I think they're all kind of saying, and everybody's kind of agreeing that this trial, the second time around, is going to be different. I think we can expect to see a lot of different things this time around than the first trial. We definitely see that Hank Brennan has a different approach. We may see some different things by cross-examination, how he structures his case, who's going to be called first, who's going to be called second, etc. First week, second week. So we'll see about that. Do want to thank Glenda Carnes. I hope I'm saying your name right, for the super sticker. I appreciate that. Here's a question, Eugene McLary, and this is something that also Yannetti didn't bring this up, which I don't know, has me scratching my head a little bit. Why doesn't this phone show inside house or in the basement area? So what they do have, and they did have some evidence last time about how far his phone could have been, and only the outside of that perimeter was not even inside the house. How are they able to locate that phone? But again, there is some pretty strong data that his phone went up and down steps and took 84 steps or whatever it is The Apple data showed that part of his phone. And that's some pretty strong evidence of third-party culprit. He went up and down stairs. So your interpretation of what he was doing, or whether you're able to trick the phone in that way by registering steps when really it's not taking steps, that's argument. The evidence is that the phone took steps and went up and down stairs. And he didn't mention that, Yannetti. He didn't mention that in his argument. That's part of their evidence for third-party culprit. Interesting. Here's a question. If acquitted, does Reed have a decent civil case against the Commonwealth? I definitely see that happening. If she gets acquitted, I can definitely see her filing a lawsuit, civil rights violation against all these, the Canton Police Department, the Massachusetts State Police, the individual police officers that were involved, for Proctor. I can definitely see that happening. I think my brother, who's a civil rights attorney, would be happy to take that case. But she's got to get an acquittal first. Got to get the acquittal. BC, have you watched the videos of the taillight experiment on YouTube? I know I saw a bunch of different videos about taillights. I got them coming out of me. I'm not exactly sure which specific one you're talking about, but there's so much stuff on this case, and I try not to go too far down a rabbit hole. As you all know, I like to limit my education on this case from what I actually see in court and from the court documents. So, and all these other stuff that people put together are, it's something that I'll take a look at. But it's not, until I actually see something like that in trial, I don't put too much weight behind a lot of this. So I know that there's a lot of experiments going on and people talking about it and, giving their own life experience about, being in car accidents or being bit by a dog and things like that. But for me, and I think that's best for you, all of you guys out there, is that I limit my education about this to what I actually see in trial and what I see in the hearings and what I read from the court documents. Karen's biggest mistake is the media interviews, especially that she's open and talkative. The more open you are, the more vulnerable you become. And I 100% agree with you. If you're on Karen Reed's side, really, why is she giving all these interviews? Shouldn't be doing that. Even if she is completely 100% innocent. Attorneys know how to use your statements and words against you. That's what we're trained to do. So we can take your innocent sentences and try to make it look like you're lying, or try to make it look like, why are you stating it this way as opposed to that way? Why wouldn't you just say straight out, when you ask this question, this way, why don't you answer it this way? Why don't you answer it that way? So that's what we're trained to do. And Hank Brennan is going to do that. He's going to be trying to use all of her statements against her. Looks like court is going back in session.
So questionnaire, very similar. So I have a question. So the Commonwealth, on your number 5 on the first page, I don't like the 2 questions in a row, 4 and 5. I don't think we need 5. Is that okay with you, Mr. Brennan? I don't think we need both.
It should be done.
Yeah. So that's out. So I'll go through, actually, I'd like to go through the first page of each. The first page of the defendants, number 13. Do you believe law enforcement officers are generally fair and accurate in their investigations? Who's arguing this for the defense?
I can argue it.
All right, so I don't have a problem with that, but it makes sense that we put it after 8. Those series of questions.
No objection to that.
All right, any objection to question number 13 and putting it at 9, Mr. Brennan?
I don't have any objection to moving it after 9. I think it's a bit one-sided, it means towards, or one side, but I don't have a strong objection to it.
And we can balance it if you want to suggest some language.
If there's an invitation to balance, I'll need a moment.
All right, so you can suggest something at some point. All right, so now moving on to the second page. The Commonwealth number 17 seems appropriate to me, but if you were working for the same document, it's not in the defense when it was removed, I guess. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question, does the defense?
We didn't have a real objection to it, just wasn't a particularly useful question. We thought at the last trial, everyone said no, so in furtherance of trying to have additional space for more helpful questions, we just decided to exclude it.
All right, I think we'll keep it. There's one I do want to get rid of that caused problems last time, but we'll talk about that. All right, so thank you. So, question number 23 on the defense.
They're just going through the jury questionnaire right now.
Does the Commonwealth object to that question? I think it needs to be tweaked at the least.
We do.
All right, so what's the objection?
I think the question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but the way it's written, it invites, I think, a jury to, or a juror to usurp what their role is.
And what do you say, Ms. Riddle?
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue to have this question. But I do think a question about the judge's instruction regarding, you're entitled to your own independent individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary instructions, there's language in the charge, certainly. So if it mirrors that language, I don't have a problem with it. Otherwise, I might. So
We can mirror the
talk to each other about
court's
that.
charge.
All right, so,
We would agree to that as well.
okay, thank you. Number 25 are defendants. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crime charged, what would your vote be? I tell them throughout the trial, they're not to speculate, they're not to make up their minds until all the evidence is in. I'm not going to even suggest that this is appropriate. So I'm not going to include that. There are enough questions on reasonable doubt, presumption of innocence, and defendant not testifying. So that's out. So the question, also, is there any reason why you do or do not want to sit on this jury? I don't think we should invite them to decide whether they want to sit on this jury or not. I think we did give this last time. I don't know what the responses were. Does anybody have any information on that for me?
I think most of them were no. I think 27 kind of hits the same sort of, if you
Right,
have
if that-
general concerns about the case, so I don't have a strong objection.
If that's what we're getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing, I don't want to bring it back.
May I alert the court's attention, there's two on the first page that were slightly worded differently in the Commonwealth's proposed questionnaire and the defendant's.
Oh, okay, which
proposed
numbers?
questionnaire. If the court looks at number 4 on the defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5,
Yeah,
so that's one question.
so that's, and I just got rid of Commonwealth 5.
Perfect.
So this one's better, so we will use that.
Okay, and then number 7 that was proposed by the defense, that is the same, similar question as number 8 in the Commonwealth's proposed questionnaire.
Yes,
It's just different language.
I thought it was the same.
So we changed it to say, we tend to believe or disbelieve law enforcement officers, firefighters, or first responders more than a civilian witness simply because of their occupation, as opposed to automatically believe.
So we typically ask you automatically, what's the Commonwealth's position on this?
I have no strong preference on the third and fourth.
All right, so I will think about that, Ms. Hamel.
Thank you, Your Honor.
So the question that I don't like, and you may remember, causes a lot of jurors to say, I have no idea what you're talking about. 21 on the Commonwealth's, 20 on the defense. So you may find the defendant guilty based on circumstantial evidence, but you cannot find the defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
I'm sorry, can you repeat that?
It's your number 20. I'm not gonna read it again. It caused a lot of trouble before. I think in every single one, I had to repeat myself with the instruction that I gave in anticipation of this. I gave them a pre-charge on circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that, it's just the way that it's
Does the
phrased in the
Commonwealth?
Commonwealth's questionnaire.
It's just confusing in my mind.
Okay, it took up, if you remember, it took up an inordinate amount of time, virtually every single juror.
We have no problem with that.
All right, so that would be omitted. All right, so that's that. Ms. McLaughlin, I think you said, and I think I cut you off the other day, that the third page was right from Chisholm. I reread Chisholm on 95 pages of it the other day, and I didn't see it. Where does this third page come from? The publicity.
The questions come from Chisholm, that were asked in the juror questionnaire. The other, some of the other cases, questions were part of the juror questionnaire in the prior trial that just moved over to this page. So this page dealt with a questionnaire exclusively on pretrial publicity.
Okay. All right, I think that we all know many, if not most, and perhaps all potential jurors have heard about this case. Giving them the opportunity to write the details that they would call down may take an awful lot of time and space that we don't have on this form, and frankly, I don't think we have. So, what are your positions on, what's your position on 3?
Here, I may, I can just hand up the excerpt from the Chisholm case that outlines.
So now they're actually talking about the publicity extra paper with the jury questionnaire, which number 3 is, what are the details of the case that you are able to recall if they've heard about the case? And there's 2 lines. So if someone's heard about this case, they've probably heard a lot more than what 2 lines can fill up. And I think if I was filling out this questionnaire myself, I would say, I know more details than these 2 lines allow. I'm happy to elaborate if I ever get chosen. But there's just 2 lines there to write your very small lines, by the way, and narrow lines. So that's what they're talking about now.
All right, I'm not sure 2 lines are enough space for it. All right, I guess we'll see what we can do. I didn't realize it came directly, same language. Okay, looks like we're giving this a third page of the questionnaire. Yes, Mr. Chairman.
Your Honor, I want to bring the court's attention something that the court and counsel just discussed, question number 7. Can I ask the court to direct its attention to
All right,
question?
which
Sorry,
third page or previous page?
the defendant's questionnaire on the first page. That was the question I think the court's going to consider whether to use the word automatic or tend to.
Yeah.
I believe that should be broken into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders, more than civilians, just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into 2 questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic?
I'm not worried about the automatic part, it's the believe or disbelieve. That's the part that doesn't help us.
Right, so if it's automatic, simply because of a person's occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person a juror? Why do you need it?
Because that tells us, it would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I automatically disbelieve police officers, or automatically believe police officers. Those are two very different mindsets.
So I understand that. I'll consider it. I think we keep it as one, and then if they say yes, we acquire it. Maybe. Let me see.
Okay. Thank you.
All right, so it looks like we have the third page as well. I think I have the statutory questions that I would ask of the notary. If we take that question that Mr. Jackson just talked about, I can ask each individual juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she is a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case, ask exactly like that. So it makes more sense to me that we do it that way rather than a questionnaire, but if you wanted a questionnaire, we'll stay as is. So what's your thoughts on that?
That would be the best preference.
Do you care, Mr. Brennan?
You prefer a questionnaire?
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors have been summoned, is my understanding. We will get some portion of that, we will get some fraction of that maybe, just on how it goes with whether people are here and available to testify on that date. To serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave and I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied, might take an hour and a half or 2 hours if we have a really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long it takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors or so, send them home, and have them come back the next day at 11 o'clock. If we've got fantastic court security here, hopefully we've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home, have them come back the next day at 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2 hour process, filling out the forms, having a copy given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do? Mr. Brennan?
Of course. No objection.
All right, so we'll try and figure out something that way to get things moving that way. All right, the list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury and statement of the case to the jury. Do you have that yet?
We are not combining them.
All right, so I need you to look at that, and a statement of the case to read to the jurors. It's all part of the final trial conference, so I should have had it last week. So I need that by Thursday. Is there anything else we need to discuss today?
There's still a few outstanding issues. One is ARPA. And
Where do
so,
you stand with discovery on that?
I received some 2 letters last night. It is not the information I was seeking from my motion that was allowed by the court. And so I have great concern about waiting for the day before the testimony to pursue the other discovery that I'm entitled to.
What do you say, Mr. Jackson? Say, Mr. Jackson.
Your Honor, I do not know what Mr. Brennan is referring to with regard to what he's looking for and great concerns. The hyperbole is unnecessary.
So there was a motion allowed, so that should be able to, there was a motion for the discovery allowed, a while back.
It
So
was.
that should narrow,
Right.
right?
Pardon me?
That should narrow things.
It does, and we have not, I attempted to confer this morning with Mr. Brennan, and my recommendation to the court would be for us to confer further, because I just don't understand what he thinks is out there, but we haven't conferred fully either.
Okay, all right, so do that, we can address this next week. I think we're going to have plenty of time to sort of tie up loose ends during the impanelment process, because I think it's going to take a very long time to get a jury.
Understood. And I expect we'll file a response to a proposed expert. We received a report last night, and I didn't receive it until later, which I want to have a chance to respond to.
And Your Honor, if I could, please, one more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction request, and then the assent of the Commonwealth that they would redo what they had provided, that 140 slide presentation. We did receive that, but we received a lot of other material in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up. I respectfully request that we, Your Honor, grant us please 2 more days than what we had to take a look at that, because it's just taken an extraordinary amount of time.
Okay, makes sense, Mr. Brennan?
I can be clear, there's no new information. What Mr. Welch did is that all the information he based each of his opinions on was in the gigabytes we provided to the defense, but he wanted to make it as seamless as possible, so to effectively hold their hand through it. He put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
Your Honor, if I may, I don't disagree with Mr. Brennan's characterization. However, it is still 140 slides or so. I was expecting a rather substantial narrowing. So what we have to do is we have to go, and unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time, because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation. So I'd appreciate the 2 extra days.
All right, so when does that put us at? What was the time frame originally?
I'm sorry, Your Honor, I don't have the specific date handy right now.
The time frame as far as the response,
Yes.
well, we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters, and as you see, the third dog experts report.
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, was when was our time? Because Your Honor had given us time to respond. And I apologize, I don't have that date, but what I'm just asking for is 2 more days beyond it. But
I don't think I gave it to you.
yeah, okay.
So you have 2 days to respond to that?
I have 2 days from today.
Yes.
Okay.
All right. So there are a few matters outstanding. I will have the decision on the motion to dismiss, should by the end of the day, buffer zone, probably by the end of the day. And I'll get everything else done as quickly as possible. All right. Anything else?
The only other thing is the logistical issue as it pertains to both the voir dire process as well as during the trial. I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something that's slaved to a microphone up at the bench at sidebar so that she can listen in on both. It's very, I want to avoid that if possible. It's clunky. It's especially during the voir dire process. I think it would be uncomfortable, and quite frankly, I think it would be a little inappropriate to have jurors with Ms. Reed standing right there with them and with us.
It's done all the time.
It makes sense all the time, but
It may be something you're choosing not to, but she has every right to be there at sidebar. So you say you don't want that, you want some accommodation. I don't know if we can do it. I'll think about it.
we could. Well, one of the things that we were talking about is potentially a closed circuit wireless microphone up the bench and a set of headphones here that she can listen in.
Put it all in writing. I
Okay.
would like to have had it before today. We're going to be moving around courtrooms. It may not be able to happen.
Okay.
All right, so the alternative is she can come to sidebar for any sidebar discussion, impanelment, whatever. It's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing and perhaps I've got the plan in the back of my head. I'll put it in writing. And
We have a lot of different equipment that we need to make sure has priority. It's in the
Understood.
courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, Thank you for entertaining.
All right, one thing, when we get the juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what my decision is here, other than the 10-2 versus automatic. Let's go with 10-2, and I can either do that inside or in the phone. What I'd like you to consider, and lawyers have done this in other cases that I've had, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16, both sides agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that, and maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires on folks that we sent home to have them come back the next day, to just call 5 people, the court officers call them and tell them not to come in based on the questionnaires. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in the case that we tried, that we had changed venues on, because of the pre-trial publicity also. All right, anything else?
No, thank you.
Your Honor, there was a motion for reconsideration that was filed with regard to the metadata underlying. I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a full argument, I'm happy to do that, but we just wanted to make sure that that gets decided.
Okay. All right, there's still a few outstanding.
Thank you.
All right, anything else?
Nothing to say.
All right, we'll see you on Tuesday.
Court, all right, please.
All right. Well, that's going to do it for today. So she's going to come out with the opinion on the motion to dismiss today. So keep your eyes peeled for that. But I can tell you, there's no way that that's going to be granted at this point. Not the way that they're talking about jury selection and everything. So she's not going to dismiss this case. That's pretty obvious. But we will be able to see the opinion and why she feels that the conduct does not rise to prosecutorial misconduct, or Brady violations do not rise to a sanction of a dismissal. So we're going to be seeing all of her reasons laid out in opinion today, and hopefully we'll get it earlier rather than later so that I can do a video going through that opinion, whether I agree or not, hopefully by today. But if not, if it comes out really late, it's going to be difficult to do a video on it today, maybe tomorrow, because the next hearing is not going to, the next court date is not till Tuesday, which I think is not going to be the day of the trial, day of jury selection. So we're just going to all be kind of be in the dark until they actually choose a jury. Let's put this question out. I don't understand how she can just leave the motion to dismiss hanging this close to trial and jury selection. Is this something that is commonly done? Well, it's more common when you know that the answer is going to be denied. So she kind of knew that probably going along this whole time. So that's why that's happening. So it's just going to be denied. Wouldn't the jury process be faster if attorneys can ask their own questions? And actually, not necessarily. Just the opposite. Attorneys can really talk, trust me, and we can ask a lot of questions of every single juror, and it can get out of hand. Definitely could. I don't think that that's a reason why they shouldn't be allowed to do it. I think there's a very important part of this process where the attorneys should be able to ask questions of the jurors, and you'll be able to get a lot better answers and a lot better understanding of these specific jurors' biases and prejudices and feelings and way they bend and way they lean. So it's you're definitely. I think you're not going to get as good of an answer or as truthful as an answer or as full of an answer when you just have the judge kind of asking questions in a very broad way. And even if there's going to be some sort of follow-up, there's a lot more that you can get when you're an attorney. You know what you're looking for, and you can have a conversation with a specific juror, and you can kind of just move along with the conversation and keep asking more questions and more questions of that specific juror, and then get to the bottom of what this potential juror's problem may be, and why this juror maybe needs to be stricken for cause. So, or struck for cause. So, in terms of it being a faster process, probably not. But I think it's still important, and I think it should be done. But that's not what Judge Cannoni is doing. And I do want to just make a little shout out to our mod Blurry Lights, taking care of the chat, making sure everyone behaves, thanking all the donations and things like that. So thank you very much to Blurry Lights for being with us today and acting as our moderator. So anytime soon you will have 20K subscribers. Well, that's the next milestone. So let's just get there, and then we'll move on to the next milestone, which will probably be, I don't know, 50,000. So you gotta baby steps, one subscriber at a time. So that's the idea. Just keep your head down, keep working hard, bring out good content, and the subscribers will most likely come. So that's our plan here. Okay, well, thank you everybody for joining us today in the live stream. Hopefully we will get out a recap of what happened today, even though there wasn't so much, but we'll definitely try to do a quick recap video today of what happened today. And then we're kind of going to be in the dark for a little bit, unless we're going to see the opinion on the motion to dismiss, and then not sure what else we're going to be seeing from the Karen Reed case until there's actually a jury that's picked. But we'll still be following it and seeing if there's any news to report on. Otherwise, we'll have to start looking at some other cases. I know that the Lori Vallow trial is supposed to start March 31st. Maybe they'll pick a jury a lot faster. Maybe we'll do some Lori Vallow stuff. That's what you guys want. We'll keep track on the Donna Adelson case as well. Some motions being filed in that case. So maybe there'll be some more of that. But if this case may go silent for a little bit. So we're going to have to get your Robert Alessi. You might feel withdrawal not being able to hear Robert Alessi argue. I know a lot of people want to hear him argue, especially me, and to read his motions. So, oh yes, and also the Koberger case. So yeah, the Brian Koberger case is also something that I have been keeping my eye on a little bit, not as intently as I probably should be, but it is something I have my eye on. But Karen Reed has really been bogging me down a lot, and then Donna Adelson. But I know Koberger's heating up. There's just something like 42 motions in limine that were filed. I have to do like 42 different videos on that in order to keep up with that. So we'll see. But as that case probably goes closer to trial, Brian Koberger, as that case goes closer to trial, we will probably be following that also. Doing the analysis on the trial. Should be a very interesting trial. So I'll definitely be looking at that as well. I think that's sometime maybe in June or July. So we got a full few months ahead of us. We got Lori Vallow coming up. We've got Karen Reed. We've got Donna Adelson in September. We got the Brian Koberger case. So should have a full year of true crime cases that we're going to be filing. So, all right. Well, anyway, thank you all for joining us today, and we'll see you next time. Thank you all.